My name is Sara Kamali. I'm 44 years old. When I was 37, I spent 11 weeks in a rehabilitation facility following a serious accident. I was not unconscious for 11 weeks. I was fully aware, fully present, in pain and working through it. I knew where I was. I knew what was happening in my body. What I did not know, what I was not told, what was being carefully managed in my absence, was what was happening in my house. My house. The house I had bought in 2007, alone, at 30 years old, with a down payment I had saved over 8 years of careful work. A 3-bedroom house in Rockville, Maryland, that I had renovated room by room over the following 4 years, doing some of the work myself and managing the rest. A house where I had built a life that was entirely mine, organized entirely around my choices, and that was, of the things I had accomplished in my adult life, the accomplishment I was most proud of. When I came home from the rehabilitation facility in March of 2016, the house was no longer mine. My mother and my brother Reza had sold it. The sale had closed the previous December. The proceeds had been distributed, to debts they claimed were mine, to costs they described as expenses of managing my affairs during my incapacity, and to an account that I later discovered was primarily under Reza's control. My share of the proceeds, after these deductions, was a check for $12,400. My house had sold for $490,000. I sat in the apartment my mother had found for me, a 2-bedroom apartment in Gaithersburg that she had arranged as part of what she called taking care of things, and I looked at the check and I thought about the 8 years it had taken me to save the down payment and the 4 years of renovations and the 9 years I had spent building something that was mine. $12,400. I did not cry. I have thought about why I did not cry, and the answer I have arrived at is that the situation was too large for the ordinary emotional response of crying. What I felt instead was a specific quality of clarity, the clarity that comes when something you have been uncertain about is resolved. The clarity of understanding, precisely and completely, the shape of what had happened. Then I started figuring out what I was going to do about it. What I did took 14 months, 3 attorneys, a forensic accountant, a specific document that changed the legal shape of everything, and a family meeting that my mother still calls the worst day of her life. It was not the worst day of mine. Tell me in the comments where you're watching from. If you have ever been vulnerable at exactly the wrong moment, stay with me. I need to tell you who I am and how I got to where I was when the accident happened, because the story does not start with the accident. It starts much earlier, with the specific shape of a family and the way that shape produces certain outcomes when certain conditions arise. My mother, Parisa, came from Iran in 1980. She was 22. She came with very little, the specific combination of determination and resourcefulness that immigrants who leave under difficult circumstances carry when they arrive. She built a life in the Washington area through hard work, and through a specific intelligence about people and situations that she has always had and that she uses in ways that are sometimes admirable and sometimes not. She married my father, Ahmad, in 1986. He died in 2003, when I was 26. He was a quiet man, methodical, whose primary qualities were reliability and honesty. I have thought often since 2016, about what my father would have done in the situation that arose after my accident. I believe he would have found it impossible. I believe the honesty that was his primary quality would have made the management of what was done to me unworkable. This is perhaps why it was my mother and Reza rather than my father and Reza. The situation required a specific capacity for self-justification that my father did not have. My brother Reza is 2 years older than me. He is a person of genuine charm and significant financial precariousness. These two qualities have coexisted in him throughout his adult life. He works in sales, has always worked in sales, is good at it in the way that charming people are often good at sales without being good at the underlying management of money that sales generates. He has been in financial difficulty, in various forms, for most of his adult life. Not dramatically, not a person in crisis so much as a person who is always slightly behind, always managing the gap between income and expenditure, always with a project or an investment that is about to resolve the underlying situation. The underlying situation has never fully resolved. There is also my sister Layla, who is 5 years younger than me. Layla is the family member who told me what had happened when I came home from the rehabilitation facility, who sat in the apartment my mother had arranged and told me the specifics, because she had been excluded from the process but had watched it happening and had kept notes because she knew it was wrong and she did not know what else to do with that knowledge. Layla is the person to whom I owe the most gratitude in this story. Without her notes, without her specific and documented observation of what had occurred, the legal situation would have been significantly harder. My career. I want to tell you this because the assumption that I somehow did not need the house, the assumption that underlies my mother and Reza's self-justification, was built on an incorrect picture of my financial situation. I had worked since I was 16. Retail, then administrative work, then, after my graduate degree in information systems, a position at a federal contracting firm that was solid and grew steadily over the following years. By the time I was 30, I was earning enough to save meaningfully. The down payment for the house, $78,000, which I put toward a house that was listed at $312,000 in 2007, was 8 years of deliberate saving from the age of 22. The renovation that followed the purchase was paid for the same way. I did not take out a home equity line. I did not borrow. I saved for each project before beginning it, which meant the renovation happened slowly but without debt. By the time the accident occurred in 2015, I had $340,000 in equity in the house, a mortgage payment I managed easily from my salary, and retirement savings that were modest but growing. I also had no close family involvement in my finances. My bank accounts, my investment accounts, my property, these were entirely under my own management. My family knew in general terms that I was doing well. They did not have access to specifics. Or so I believed. What I learned after the accident was that Reza had been studying my situation with considerably more attention than I had realized. He had information about the value of the house that was more specific than I had shared. He had information about the equity. He had, it emerged during the legal process, contacted my mortgage holder once in 2014, over a year before the accident, to inquire about the balance on the mortgage. He had been paying attention to what I had built for some time before the circumstances arose that gave him an opportunity to reach for it. The accident happened in September 2015. I was driving home from a work event on a Friday evening. The weather was clear. I was not impaired. A driver who had run a red light at significant speed hit my car on the driver's side. The impact was severe. I do not remember the accident itself. I have a clear memory of the work event, a retirement dinner for a colleague I had known for several years, held in a restaurant in Bethesda, and then nothing until I was in the hospital, 2 days later, having been told that I had a spinal cord injury, 2 broken ribs, a shattered left wrist, and a traumatic brain injury that was described as moderate and that had produced the 2-day gap in my memory. The spinal cord injury was not complete. I retained significant function, and the prognosis was for substantial recovery with intensive rehabilitation. But the recovery timeline was described in months, not weeks. I would be in the hospital and then in a rehabilitation facility for an extended period. I would need help when I came home. My mother arrived at the hospital the first day. Reza came the second day. Layla came from Philadelphia, where she was living at the time, and stayed for a week before returning to her job. In the first days, when I was managing the immediate reality of the injury and the treatment plan and the shock of what had happened, my mother and Reza had a conversation with my medical team about my situation. This conversation was appropriate. I was incapacitated in ways that required someone to interface with the hospital, but it also established them as my primary family contacts in the hospital system, which would have downstream effects I did not anticipate. At some point in the first week, Reza asked to see my phone. He said he needed to manage some things for me while I was unable to. He had a specific list: my bills, my utilities, correspondence from my employer. All reasonable, all things that needed to be managed. He also, at some point during this access, photographed or otherwise captured information from my phone that he used later. I know this because the legal process produced phone records, and Reza's records showed contacts with my mortgage company and my bank during the week of my hospitalization that could not have occurred without specific account information. 2 weeks after the accident, my mother and Reza brought me documents to sign. I want to tell you about this specifically because it is the central act, the moment that made everything that followed possible. I was in the hospital. I had a moderate traumatic brain injury that was resolving but had not resolved. I was on pain medication. The documentation I was shown was legal in nature, a power of attorney, authorizing my mother and Reza jointly to manage my affairs during my incapacity. They told me it was necessary. They told me it was temporary. My mother said, "Sarah June, we need this so we can pay your bills and keep things running while you are getting better." I signed it. I want to be honest about this moment, because the honest version matters. I signed it. I was not unconscious. I was not completely without capacity. I was injured and medicated and frightened, and I trusted my mother and my brother, and I signed the document they put in front of me. What I did not read carefully, what I did not have the capacity to read carefully in that condition, was the scope of the power of attorney. The document, which Reza had prepared through an attorney whose name I later investigated and whose professional relationship with Reza predated the accident, was broad. It authorized them to manage real property as well as financial accounts. It authorized them to sell assets that it determined were necessary to cover expenses related to my care. It had a provision that allowed the power to be exercised without further consultation with me under specific conditions. Those conditions were broadly defined. My attorney, when she reviewed the document 2 years later, described it as the broadest power of attorney she had seen outside of a situation specifically designed for comprehensive incapacity. She used the phrase drafted to enable rather than protect. I had signed a document that, in my brother's interpretation, authorized him to sell my house. I was transferred to the rehabilitation facility in late October 2015. The rehabilitation was intensive, 4 to 6 hours a day of physical and occupational and cognitive therapy. I was improving, clearly and consistently, but the improvement required everything I had. By the end of most days I was exhausted in a way that left no bandwidth for much else. I called my mother every few days. She told me things were fine. Bills were being paid. The house was fine. I should focus on getting better. I believed her. I was exhausted and I was getting better and I believed her. In November 2015, my mother told me on a call that she and Reza had been looking at my financial situation and were concerned about whether I could maintain the house expenses on long-term disability income. I told her I was managing. She said she wanted to make sure. She said Reza had some ideas about how to structure things better. I said okay. I said we could talk when I was more clear-headed. She said of course. She said there was no rush. The house sale closed on December 14, 2015. Layla called me on December 18, 2015. She was not supposed to tell me. She told me later that she had argued with herself for 3 weeks about whether to call, that she had convinced herself several times that it was not her business, that she had started to believe the version of events that my mother presented, that the sale was in my best interest, that the proceeds were being managed responsibly, that I would understand once I was better. But she could not maintain the belief. She had been there for some of the conversations. She had seen the documents Reza was preparing before my mother had even gone to the hospital with them. She had seen the attorney Reza had used and had looked him up and had found that he had a limited professional history and had worked on several real estate transactions for Reza's associates. She had seen the numbers, not all of them, but enough. She called me on December 18th and told me what she knew. I listened to the entirety of what she said without speaking. Then I asked her one question. Layla, do you have anything in writing? She said yes. She had been keeping notes. She had photographs of some of the documents she had seen at my mother's house. She had a record of dates and conversations. I told her to keep everything and send me copies of whatever she could. Then I called my attorney. I did not yet have an attorney. I called Judith Marks, who was a partner at a firm that had done some contractual work for my employer, and told her I needed to speak with someone about an estate and property matter as soon as possible. I met with Judith 2 days later. Judith's initial assessment of the situation was calm and specific. She said the power of attorney, if it had been properly executed, meaning I had signed it with adequate capacity and understanding, might give Reza and my mother the authority to have conducted the sale. She said the question of whether I had adequate capacity when I signed was going to be central to any challenge. She also said that even if the power of attorney was valid, there were still obligations on the part of the agents. They were required to act in my best interest. They were required to account for what they did with the proceeds. They were required to have reasonable grounds for the actions they took. The claim that my long-term disability income was insufficient to maintain the house was worth examining. If the claim was not accurate, if my income plus the short-term disability benefit plus any insurance settlement from the accident would have been sufficient, then the justification for the sale was undermined. She also noted that my employer's long-term disability insurance was likely to provide 60% of my salary for an extended period. My salary was $87,000 a year. 60% of that was $52,200. My mortgage payment was $1,740 a month, or approximately $20,880 a year. Even without the insurance settlement from the accident, which was a separate matter, I had sufficient income to maintain the house. Reza knew this, I said. He had my financial information. If he knew this and still represented to you and to others that the house was financially unsustainable, Judith said carefully, that is relevant to the question of whether he was acting in your best interest or his own. We agreed on the next steps. Judith would obtain the full documentation of the sale and the power of attorney. She would commission a capacity assessment to address the question of my cognitive state at the time I signed. She would request a complete accounting from Reza and my mother of the proceeds. We would see what came back. The capacity assessment was the first significant development. Judith hired a neuropsychologist who reviewed my medical records from September and October 2015, the period during which the power of attorney was signed. The assessment addressed the specific question of whether my moderate traumatic brain injury and the medication I was on at the time had affected my capacity to understand and intentionally execute a legal document. The neuropsychologist's report was careful and specific. She noted that moderate TBI at the level I had experienced commonly produces cognitive effects that are relevant to legal capacity: reduced processing speed, impaired executive function, difficulty understanding complex documents, increased suggestibility. She noted that the medication regime I was on in the period when the document was signed included pain management and sedation that would have compounded these effects. Her opinion, that at the time I signed the power of attorney, I was operating with diminished capacity that would have affected my ability to understand the full scope and implications of what I was signing. She noted that this did not mean I lacked all capacity, but that the legal standard of capacity for executing a power of attorney required more than minimal understanding. This was not a definitive ruling. Legal capacity is ultimately a question for a court. But the neuropsychologist's opinion created a substantial question about the document's validity that was going to need to be addressed in any proceeding. The proceeds accounting arrived in late March 2016, after Judith's formal request had been met with what she described as initial stonewalling that became cooperation when she indicated we would seek a court order if necessary. The accounting was presented by Reza's attorney. I reviewed it with Judith. The house had sold for $490,000. The mortgage payoff was $148,000. Real estate commissions and closing costs were $29,400. These were standard and appropriate. The remaining $312,600 had been distributed as follows: medical expenses and rehabilitation costs, $67,300. I had health insurance. My health insurance had covered the vast majority of my medical costs. My out-of-pocket costs, which I had not been paying because I was in the rehabilitation facility and Reza had been managing my accounts, were approximately $8,200 according to my own insurance records. The gap between $67,300 and $8,200 was $59,100. When Judith requested supporting documentation for the medical expenses claimed, Reza provided a list of items that included some legitimate costs, the co-payments, some medical equipment, and a large amount of costs that were either unverifiable or were, on examination, not related to my care at all. Property management and maintenance during sale, $31,200. The house was sold in December. The accident was in September. 3 months. $31,200 in property management for 3 months. Judith obtained the records from the property management company Reza had hired, an entity called Clean Slate Property Services, which turned out to have been registered in October 2015, 1 month after the accident, and whose registration address was Reza's home address. He had created a company to pay himself for managing my property, using my own money. Legal and administrative costs, $22,000. The attorney Reza had used to prepare the power of attorney charged $3,500 for that work, which was on the high end but not extraordinary. The remaining $18,500 was listed as ongoing legal consultation related to the estate. There were no invoices. Repayment of family loans, $48,000. I had no family loans. I had never borrowed from my family. When Judith requested documentation of these loans, the response was a document, undated, that appeared to list a series of cash loans made to me by my mother between 2008 and 2014. I had received no such loans. Transfer to Sarah's account, $12,400. The $12,400 check I had received. Transfer to estate management account, $131,700. The remaining amount, in an account that Reza had set up and was managing. Judith reviewed this accounting and said, "This is not a complicated situation. This is a straightforward misappropriation of funds with a paper trail." Before we went to the legal proceeding, something happened that changed the shape of everything. I had come home from the rehabilitation facility in March 2016. The apartment my mother had arranged was adequate, it was safe and functional, and I had everything I needed for the continued recovery. But it was not mine. In April 2016, as I was becoming more physically and cognitively capable, I began going through the boxes that my mother had packed from the house. She had done the packing and had done it with her usual efficiency, everything labeled, organized, accessible. Most of it was in storage in Gaithersburg, some of it was in the apartment. I had not yet gone through all the boxes. Some of the boxes were not things I was ready to open yet. One Saturday in April, I opened a box labeled Office Documents. This was a box of papers from my home office. Files. Tax documents. Professional records. The specific accumulation of a working life's paperwork. At the bottom of the box, in a folder that I had labeled in 2013 and then apparently forgotten about, was a document I had not thought about in 3 years. The document was from my mortgage company. It was a letter dated March 2013, addressed to me, following up on a request I had made in early 2013 to understand the process for adding another person to my mortgage, specifically, for adding a name as a co-borrower. I had inquired about this in early 2013 when I had briefly considered whether to have my then partner's name added to the house, which we had discussed as part of a conversation about our shared future. The relationship had ended in the summer of 2013 and the question had never proceeded. The letter from the mortgage company outlined the process. It also stated something that I read in April 2016 and that I immediately photographed and sent to Judith. It stated that under the specific terms of my mortgage, any sale of the property required a 60-day advance notice to be provided to me directly, at my registered address, by certified mail. The notice was a contractual protection, a provision my mortgage had included because I had specifically requested it when the mortgage was originated in 2007, as a protection against the kind of fraudulent transfer that was then becoming more common in real estate fraud cases. The notice had not been provided. The sale had closed without any certified mail notice to me at any address. The power of attorney, even if valid, did not override the contractual terms of my mortgage. The mortgage was a contract between me and the lender. Its protective provisions ran to me personally, not to any agent acting on my behalf. The 60-day notice had to go to me. It had not gone to me. The sale had been conducted in violation of the mortgage contract's own terms. Judith, when I called her about the mortgage letter, was quiet for a moment. Then she said, "Sarah, I want you to understand what this means." I told her I thought I understood. She said, if the sale violated the mortgage terms, the sale is potentially voidable. Not just challengeable, potentially voidable. This is not simply about recovering money. This is about whether the transaction itself was valid. I asked about the buyers. The house had been sold to a family who had done nothing wrong. Were they affected? Judith said this was the complex part. The buyer's rights were also relevant, and the law had protections for good faith buyers. It was unlikely the house would actually be returned to me given those protections, and forcing that result would be neither practical nor fair to people who had done nothing wrong. But, she said, the existence of the contractual violation changes the nature of what Reza and your mother did. They sold your house without complying with a specific contractual requirement that existed specifically to protect you. That moves us from a question of whether they exceeded their authority under the power of attorney to a question of whether they breached specific contractual protections. The legal picture becomes cleaner and more serious. She said, we're no longer arguing about the scope of the power of attorney. We're arguing about a specific breach of your mortgage contract that cannot be explained away by any authorization your mother and brother had or claimed to have. That was the shift. The mortgage letter was the thing that changed the shape of everything. There were also the proceeds. Even if the voiding of the sale was not practical, the misappropriation of the proceeds was fully actionable. The false medical expenses. The property management company Reza had created. The fake legal costs. The fabricated family loans. Judith built the case in parallel tracks. The capacity challenge, the neuropsychologist's report, my medical records, the circumstances of the signing, the breadth of the power of attorney that suggested it had been designed for comprehensive exploitation rather than temporary assistance. The proceeds misappropriation. The forensic accountant Judith brought in, a woman named Christine Wu, who went through every transaction in the accounts Reza had managed and produced a report that was, Christine described, among the most clearly documented cases of financial abuse she had seen in her professional career. Not because the amounts were dramatically large, they were not, compared to some cases, but because the documentation was poor in ways that were almost careless. The property management company that was registered to Reza's address. The medical expenses that exceeded the actual costs by a factor of 8. The family loans for which no contemporaneous documentation existed. Christine's conclusion, approximately $240,000 of the $312,600 in net proceeds had been misappropriated. The $12,400 I had received was approximately 5 cents on the dollar of what I should have had. The mortgage violation, the specific provision, documented in writing from 2007, requiring 60 days notice to me personally before any sale. The absence of any such notice. The sale that had proceeded without it. My mother and Reza responded when the legal papers were served in a way that followed the same progression I described in the Marchetti situation earlier, from denial to explanation to negotiation. Their first position, through their attorney, was that they had acted entirely in my best interest and that I was confused about the nature of what had happened. My mother, specifically, maintained for several weeks that everything she had done was motivated by love and concern and that I was being manipulated by people who did not understand the family situation. This position deteriorated as the evidence was presented. When the forensic accountant's report came in and the specific documentation of the property management company was laid out, Reza's attorney's tone changed noticeably. The property management company was a problem that could not be explained as a misunderstanding. There was no interpretation of Clean Slate Property Services LLC, registered in October 2015 at Reza's home address, that did not indicate deliberate self-dealing. When the mortgage violation was presented, the letter from 2007, the certificate provision, the absence of any certified mail, Reza's attorney apparently had a frank conversation with his client. The response after that conversation was a request for a settlement discussion. The settlement discussion happened in October 2016. I want to be honest about the settlement, not because I think I made a mistake, but because I think the honesty serves people who might be in similar situations. What I could have received, if I had pursued the legal process to its full conclusion, was potentially more than what I received in the settlement. The capacity challenge could have invalidated the power of attorney entirely. The mortgage violation was a clear breach of contract with specific remedies. The misappropriation was documented. What the full legal process would have cost me was time, money, and, most significantly, the permanent destruction of any possibility of a relationship with my mother and the complete family rupture that would have followed. I have thought about this balance many times. I am not certain I made the right decision, but it was my decision to make, and the reasons I made it were real. The settlement provided full restitution of the $240,000 that had been misappropriated, to be paid from Reyes's assets and from certain family assets that my mother agreed to liquidate for this purpose. A formal acknowledgement, in writing, that the sale had been conducted without my informed consent and in violation of my mortgage contract. Reyes's agreement to cooperate with the formal closing of Clean Slate Property Services, LLC. A payment schedule with security provisions that Judith negotiated specifically to make sure the restitution actually arrived. The restitution arrived over 14 months. I also received, separately from the legal settlement, the insurance proceeds from the accident. The driver who hit me was insured, the liability was clear, and that settlement, which had been in process during the entire period of the legal situation, provided additional resources. I will not specify the amount from the accident settlement as that is not directly part of this story, but it was significant. I need to tell you about the conversation with my mother, because this is not a story about legal proceedings. The legal proceedings were the mechanism. The story is about a family. My mother and I met alone, without attorneys, in November 2016. She asked me to come to her house. I went. She was in the kitchen. She is always in the kitchen. She was making food for the meeting that I had not asked her to make, and that I think she was making because she did not know what else to do with herself. I sat at the table that I had sat at my entire life. She brought tea. Then she sat across from me and said, "Tell me what you want me to say." I looked at her. "I don't want you to say anything specific," I said. "I want you to understand what happened." She was quiet. "I want you to understand that I was in a hospital. I was injured. I trusted you. I signed something I did not fully understand because I trusted you and because I was not in a condition to understand it. And while I was getting better, while I was working every day to recover, my house was sold. The thing I had built. The thing that was mine." She was looking at the table. "Reza told me it was the only way," she said. "He said you couldn't manage the mortgage. He showed me numbers." "The numbers were wrong," I said. "My insurance covered 60% of my salary. I could have managed the mortgage. I have managed the mortgage for 9 years without help." He said, "Maman." I said it quietly. "I know what he said. What I need to know is whether you looked at what he was saying. Whether you asked for the actual numbers. Whether you saw the medical expenses he claimed and asked where they came from." She was quiet for a long time. "I trusted him," she said. "I trusted both of you," I said. We sat with that. Then she said something that I had not expected. She said, "I knew something was wrong. When the property management company, when I saw those documents, I knew something was wrong. But by that point the house was already sold, and I told myself it was done, and the best thing I could do was make sure you had somewhere to go. You knew. I suspected. I didn't know the specifics. But I knew your brother was not." She stopped. Then, "I knew something was not right, and I did not look more carefully because looking more carefully would have meant knowing something I did not want to know about my son." This is the sentence that I have thought about more than almost anything else from that period. She had looked away. Not from cruelty. Not from malice. From the specific human capacity for not knowing what we do not want to know, even when the not knowing requires looking away from someone we love. She had looked away from me, because looking toward me would have required seeing what Reza was doing. "I'm sorry," she said. It was not enough. Nothing she could have said in that conversation would have been enough. But she said it, and she said it without qualification, without the defensive reframing that people use to make apologies feel better than they are. I accepted it as the beginning of something, rather than the resolution. The year after the settlement was the year I rebuilt. I bought a house in October 2017. In Rockville, not far from the first house. 3 bedrooms, similar size, slightly different layout. A different garden that would become mine over time in the way that gardens become yours through the work you put into them. The down payment came from the restitution. There was something specifically appropriate about this, about using the money that had come from fighting for what I had built to build something again. The renovation will take longer this time. I am more realistic about timelines than I was in my 30s. But the approach is the same. Save for each project before beginning it, do what I can do myself, manage the rest. The first thing I renovated was the kitchen, because kitchens are where families gather, and I was building a house that I intended to have people in. My recovery from the accident is essentially complete. I retained full function. The cognitive effects of the TBI resolved within the first year. My left wrist, which was the most severely injured part of me physically, has about 90% of its previous range of motion, which is more than the initial prognosis suggested. I work full-time. I run. I am physically and cognitively who I was before the accident, and in some ways more than who I was before, because the experience produced certain clarities that I did not have. My relationship with Reza is over. This is the clearest thing I can say about it. There is no ongoing relationship. I see him if family occasions require my presence, and his funerals, the kind of event you cannot absent yourself from without making a statement. At those events, we are in the same room with the specific management of people who have nothing to say to each other and know it. He has not apologized. Not in person, not in writing, not through any intermediary. Whether he believes he is owed an apology, whether he believes what he did was wrong, whether he has spent any time examining the specific facts of what he did, I do not know. I have been told, secondhand, that he has told members of the extended family that I was unreasonable, and that the situation was mishandled, but that he was trying to help. I treat this information as irrelevant. What he did is documented. The property management company he registered at his address. The medical expenses he claimed that were 8 times the actual costs. The family loans he fabricated. The certified mail notice he did not send. These are not matters of interpretation. They are documented facts. What I know about him, from those documented facts and from 39 years of being his sister, is that he is a person whose relationship to money and to his own deservingness has always been organized around certain assumptions that the presence of my house in 2015 brought to a crisis point. He saw resources that he could reach, and he reached for them at the moment when I was least able to protect them. That is what I know about him. I try not to carry more than that. My relationship with my mother is different from my relationship with Reza. Different in kind and different in where it is now and where I think it might go. She did not create the situation. She allowed herself to be an instrument of it, and she looked away when looking more carefully would have required her to confront her son. These are real failures and they caused real harm, and I do not minimize them. But she has also, in the years since, demonstrated something that Reza has not demonstrated. She has examined it. She has sat with what she did and she has not run from it. She has said things to me, over several years of conversations, that required her to see herself clearly, which is a harder thing than most people are willing to do. She is in her mid-70s. She is not the person who managed the family situation in 2015. She is older, and the experience has changed her in ways I can see when I am with her. A specific quality of care about things being right that was less present before. She drives more carefully. She reads documents before she signs them. She asks questions that she did not previously ask. This is not enough to undo what happened. But it is real, and I receive it as real. We have Sunday dinners when I am not working. She comes to my house in Rockville, the new house, not the one she arranged to have sold, and she cooks in my kitchen and we eat at my table. These dinners are not always easy. There are layers in them that are not present in ordinary family dinners. But they happen, and they are genuine, and I am glad they happen. I want to tell you about something Layla said to me last year, because it closes a part of the story that I have not yet addressed. Layla has carried guilt about the period of the accident. Not guilt about what she told me, she is certain she was right to tell me. But guilt about the weeks before she told me, when she knew something was wrong and was convincing herself to stay quiet. She has described those weeks to me several times, working through them, trying to understand what she was doing and why. I told her once that I did not hold those weeks against her, that she had ultimately done the right thing, that the notes she kept, the documentation she gathered, the call she made in December, these were the things that made it possible for me to know what happened and to do something about it. She said, "But I waited 3 weeks." I said, "Layla, you were watching your mother and your brother make a decision and trying to decide whether to believe that it was as wrong as it looked. That is not a simple thing. That required you to potentially blow up your relationship with both of them. That is not a small thing to do. You would have done it faster," she said. "Maybe," I said. "But I would also have been wrong about other things that you were right about. We are different people. The 3 weeks you took were the 3 weeks you needed. You came." She was quiet for a moment. "I came," she said. "You came," I said. "That is what matters. The house in Rockville is mine now. The garden that is becoming mine. The kitchen that was the first thing renovated because kitchens are where families gather. My mother's kitchen is the kitchen I grew up in. Her spices are in the same positions they have always been. The pot she makes rice in is the same pot she was using when I was a child. When I stand in my own kitchen, I think about those 2 kitchens, hers and mine, and about the relationship between them. What was passed down and what I took and what I decided differently. How the act of building something that is specifically yours is also an act of honoring what you came from, even when what you came from also contains the people who tried to take your home. These things coexist. They have to coexist. The alternative is a story that is simpler than the truth. There are things I want to say to anyone in a similar situation, because this story should be useful and not just personal. If you are in a hospital or in any situation of incapacity, be careful about what you sign. This is difficult advice to follow because when you are incapacitated you need help, and the documents that provide help also frequently provide scope for abuse. But the specific thing I would say is, have your own attorney, not the family's attorney, review any power of attorney before you sign it. A 30-minute phone call with an independent attorney, even from a hospital room, could have changed the entire shape of what happened to me. If you are not in that situation yet but you have significant assets that could be vulnerable, a house, investments, property of any kind, put contractual protections in place while you can. The 60-day certified mail provision in my 2007 mortgage was not standard. I had specifically requested it after reading about real estate fraud cases. That specific provision, which I had added almost as an afterthought 7 years before it mattered, was the single most important document in my case. Know your contracts. Know what protections you have negotiated into the documents that govern your property. Those protections are there to be used. And if something has already happened, if you are where I was in March 2016, holding a check for $12,400 that represents the remains of something you built, find an attorney before you respond to anything your family says or does. Do not respond out of emotion. Find out the legal shape of what has occurred, understand your rights, and then make decisions. The emotional response can come later. The legal response has to be structured. I go to the house on Sundays now. My house, the new one. I go to the garden on Sunday mornings and I work on whatever the season requires. Planting in spring, tending in summer, harvesting in fall, preparing in winter. The garden is nothing like my old one yet. That garden was 9 years of building. This one is 7 years of building, and it has a different character, because I am a different person than I was in 2007, and the garden reflects who I am now. But there is a continuity, the deliberate approach, the patience, the willingness to work on something that will not look like itself for years, and to trust that the years will produce what they produce. I learned this approach before the accident, and I maintained it through the accident, and I am maintaining it still. My mother did not destroy this in me. Reza did not destroy this in me. What they did was interrupt it for a period, and cost it resources that I had to rebuild. I rebuilt. That is what I do with difficulty. That is what I have always done. My father died in 2003, and I think about him more than I did before the accident. I think about what he would have done if he had been here. I think about the specific honesty that was his primary quality, and whether that honesty would have made the situation impossible for Reza in the way I believe it would have. I also think about something he said to me when I was in my mid-20s, when I was starting to build in a serious way. Saving, planning, working toward the down payment that I would make in 2007. He said, "Sara, whatever you build, put your name on it. Make sure there is no ambiguity about whose it is. People can argue about many things, but they cannot argue about a name on a document." He was talking about business records. He was not predicting what Reza would do. But his advice was exactly right. My name was on the house. My name was on the mortgage contract with its certified mail provision. My name was on the joint account I did not know I had. Wait, that is a different story. What I mean is that the documentation of ownership, the specific and clear legal record of what was mine, was what made recovery possible. He understood this. He had learned it the way immigrants often learn things, through the specific experience of building without a safety net and understanding that the documentation is the thing that makes the building real. I learned it from him, and then I learned it again more expensively. My name is Sara Kamali. I am 44 years old. When I was 37, I was in a hospital with a spinal cord injury and a traumatic brain injury, and I signed a document I did not fully understand. While I was getting better, my house was sold. My sister kept notes. I found a letter from 2007 in a box of documents. I rebuilt everything. The house in Rockville is mine. The garden is mine. My name is on the deed. I am not the same person who signed the document in the hospital. I am better. I am more careful. I am still building. My father was right about what happens when you put your name on things. He was right about most things. I carry that too.